Welcome to Money and Purpose, a podcast exploring how to optimize your personal finances so that you can align your money with what is most important to you. I'm your host, Marianne Poon, CFA charter holder and financial advisor. Joining me today is Bettina Ristau, a probate paralegal at Pasternak and Fittis, a DC area law firm specializing in estate planning and administration. Bettina and her team have over 55 years of combined experience administering estates, and she sees what happens when plans aren't properly executed and what it costs families. Today, we're talking about what really happens when someone dies, the biggest mistakes people make, and why estate planning requires a coordinated team. Hi, Bettina. Thank you so much for being on the show. We've worked together for a while now. It's so great to have you as a guest. Thank you.
Marianne, thanks so much for inviting me. I'm really excited to be your guest today. I think we've done some really interesting and helpful things to date. And so if people can learn from our experience, then I think it makes it even more valuable.
For sure. So to start out with, do you want to just tell us what happens when somebody dies? You're the paralegal who's responsible for administrating the asset while everything gets resolved. So can you just walk us through what happens?
Right. Sure. So I want to start by saying thank you for referring to me as a paralegal and not an attorney. There's a very important distinction, which is that as a paralegal, I cannot give advice. So I'm not giving advice here. I don't want anybody to bring me up on unlicensed practice of law charges. I've managed to avoid that for 17 years. So I don't see any point in changing that now. One of the things that I've come to realize over the years is that everybody handles grief differently. And that's really the human side of my job. And every family is different and every asset setup is different. When somebody dies, maybe it was a sudden shock. Maybe there are minor children to consider. Maybe this was a long protracted illness. And so my now client, who's a grieving widow or widower or adult child or other family member, is, sort of relieved. The first thing that needs to be done, though, is the person needs to reach out to the decedent's estate planning attorney and let them know of the death. Again, depending on the circumstance, the attorney might already have a heads up. That's not unusual in my office. The will needs to be deposited with the appropriate register of wills or clerk of the court, depending on the jurisdiction. It is good to know where the original is located because that is going to determine to some level how the probate process is going to go, whether the attorney and the paralegal are petitioning for a testate estate, meaning that there is a will, or via intestacy, meaning there is no will. And really the purpose of the will is to give direction to a personal representative to distribute the decedent's assets according to their wishes. And those wishes are reflected in the will. So if there is no will, every state has an intestacy statute, which says, okay, there was no will, this is how the assets get distributed. And there are so many different permutations that I'm not going to address that now. But generally, the court is going to be looking for a surviving spouse and or children. And it goes way beyond that, but I think that's beyond the scope of our conversation today. So first thing, let the estate planning attorney know. Perhaps more importantly is take time to grieve. It's really, really important. It takes on many different faces. Some people want to be left alone. Some people want to spring into action. Some people are very quiet and private. Others are more vocal, more emotive. Truly, I've seen it all, and there's no right or wrong way.
Right. So in terms of the assets, how do you find all of these people's accounts,
So in an ideal world, the decedent will have provided all of the asset information to the estate planning attorney during the planning phase. Of course, we know that assets change over time, family situations change over time, laws change over time, but let's just stick with the basics for right now. So typically when somebody dies and the family or the fiduciary comes to us for assistance, we will have a baseline of asset information. Some clients are very reluctant to provide that information during the planning planning phase, and our attorneys explain to them why it's so important that we have that information. And really, it's to provide direction. We're not going to tell a client what to do with their assets. We're going to present them with options. Are you better off with a will-based plan or a trust-based plan? Mr. and Mrs. Jones, are you better off titling your assets one way or another? All of that is driven by what are the types of assets, what are the values of the assets, and what is the structure of the family and potential other beneficiaries. Maryland, as you know, has an inheritance tax for those folks who leave assets to non-lineal descendants or siblings. That's just the way it is. There are some exclusions, exemptions, but again, I'm not going to get into that today. DC and Virginia do not have an inheritance tax. And what I find both humorous and insulting is that inheritance tax in Maryland is defined as a tax on the right to receive. Think about that.
Right. On the right.
It's kind of nerdy.
Yes.
Yes, on the right to receive. That's one of my favorites.
You wrote an amazing article that was what your future paralegal wants you to know. One of the lines in there was, estate planning does not end when the will and the trust instruments have been signed. And that might surprise a lot of people. They think, oh, I put together a will, I got the trust, I'm done, right? I've hired the attorney, done. So can you tell us a little bit more about what you mean by that?
Absolutely. So, as I was saying, all the information that the estate planning attorney asks for at the beginning of the planning engagement is to be able to give proper advice to the planning client so that the ultimate goal is that after the client passes away, their wishes as to the disposition of their assets is followed according to their wishes. So, the will and the trust are very important and are the cornerstone of any good estate plan. However, asset titling matters. You can have an account in your individual name. Okay, that's fine. That will become a probate asset. You can have an account that's jointly titled. Well, what kind of joint titling is it? If it's joint as tenants in common, then think of it as two halves of a pizza, and one owner owns one half that is their individual property. The other joint owner owns the other half, and that's their individual property. So you're still faced with probate. Then you've got joint tenancy with rights of survivorship, which means that upon the death of the one account holder, the second account holder, by operation of law, becomes the owner of that account. That account, therefore, does not pass according to the will or the trust. In many jurisdictions, there's also a quote-unquote special form of joint tenancy that is available to married couples, and that's joint tenancy by the entirety. And again, upon the death of the first spouse to die, the second spouse is now the owner of all of the assets. And it's also important because that joint tenancy between the husband and the wife is treated as one unit.
Right.
Beyond the joint tenancy alternatives, you can also have an individually titled account and put a beneficiary designation on it, which means that at your death, the named beneficiary now owns that asset. Assets that are titled in a trust remain in the trust after the decedent passes away and are administered and ultimately distributed pursuant to the terms of that trust. Most of the plans that my firm prepares are wills that pour over into a trust. So that basically just means that any assets that were titled in the decedent's individual name as of their death without a beneficiary designation automatically pour into the trust. And then the trustee or trustees ultimately make distributions through the trust to wrap up the decedent's affairs. So what is the takeaway from this is, after your will and your trust are signed, follow through on the asset registration instructions that the attorney will give you. Put the beneficiary designations on your retirement accounts. We will give you the wording of how to do that. We will even fill out the forms for you, but you, dear client, still need to sign them and submit them. On the administration side, after said decedent is no longer here, we are going to go to, whether it's TIAA or the local bank or the financial advisor like you, Marianne, and ask for a copy of the signed beneficiary form on file. It doesn't matter what is in my decedent's file. It matters what's on file with the custodian of the assets. So that is really, really, really important. If the beneficiary designations aren't updated and submitted, then the decedent's wishes most likely will not be followed. There's a reason that the attorney drafted the plan and made the recommendations the way they did. And so if you really, really want your wishes to be carried out after you sign your will and your trust, you will take all of those next steps.
Right. So, and then I think there's another one where you say, okay, people, you've named a trust, but then the trust remains unfunded. Can you tell us a little bit more about what happened there?
Sure. So if the trust remains unfunded as of the decedent's death, all that means is that the assets that were intended to be in the trust did not get there during lifetime. They may not get there after death either, depending on what, Marianne, how they're titled. So let me give you an example through a matter that I'm currently working on. My decedent set up a trust. There were just a few little assets in the trust upon her death, but the trust provides for an ongoing trust for her adult daughter. However, the assets that probably were meant to fund that trust after death were titled at the investment firm with a beneficiary designation in favor of the daughter. So those assets don't make it into the trust. Those assets instead flow directly to the daughter. Now, fortunately, we work with the daughter and she is savvy and she knows where she needs help. And so there's really no danger. However, there are now fewer assets to go into the trust. And so they're going to pass a little bit differently upon the daughter's death.
I see. And then there could be like tax implications and things like that, I imagine.
There can absolutely be tax implications. And, you and I have talked a little bit about the three-legged stool of the estate planning attorney, the financial advisor, and the tax advisor.
Yes.
So do you want me to jump into a little more about that?
I would love
like
it.
it's stool.
Yes. Tell us about what like a well-coordinated situation is like.
Sure. So really, the three-legged stool is the estate planning and administration attorney who makes sure that the laws are followed and that the documents comply with what the law requires in addition to the decedent's wishes. The financial advisor works to make sure that the financial assets are titled the way that they need to be during lifetime. The financial advisor is of tremendous assistance after death with retitling because often there are multiple steps involved. And sure, as the paralegal, I am happy to fill out all of those forms for my client, but it's going to take me a lot more time. And I don't have the street cred with the financial institutions that the planner has. For example, in the matter that you and I are working on together right now, there were all those street name titled stocks. They were not consolidated in a brokerage account. There were multiple transfer agents who all have their own forms and all have their own rules and they all have their own requirements. It would have taken me, I'm not kidding, probably 4 times as long to do all the things that you did because you know those inner roads.
Yeah.
And you have access that I don't. And so that benefited our client because his headache was decreased. And it also benefits the beneficiaries because the administration costs are that much lower.
Right. And if we backed it up even more, I mean, this was after this client had passed. And so it's kind of like doing an autopsy at this point, and we're like the medical examiners going in and figuring out, oh, what happened? Where are these accounts? Where are those accounts? What's this? Where is that? Right. So it's become quite a mammoth project. So what would that have looked like if we had been, doing this three-legged stool prior to her death, with you, the estate, or your team, the estate planning team, financial advisor, and an accountant? That would look very different, I think, right?
It would look very different indeed, because we are doing a lot of forensic work right now that could have been avoided, and as to the third leg of this stool, it's the tax advisor. That individual is going to be capable of filing fiduciary income tax returns and understanding the implication of which tax year to elect for a given administration matter. I'm a paralegal. I don't give any advice, but the attorneys in my office are interested and are capable of advising according to the law. They don't give investment advice. That's where you come in. They certainly don't give tax advice. That's where the tax advisor comes in. We can bring these matters to the attention of the client, but we're not going to opine on them. For example, in our matter, our client needed liquidity. Between you and the tax advisor, you can come up with a plan to liquidate assets in a timely, intentional manner that meet the liquidity needs of the estate without causing a major tax issue, i.e., bill, on the income tax reporting side.
Yeah.
That is not my firm's expertise. That is your expertise and
Right.
the tax advisor's expertise.
Right. And also considering the risk of the portfolio while it's in probate also, because this is unfortunately going on for months and months and months. So we have to balance the fiduciary responsibilities of the estate and making sure that the risk profile is aligned with how the assets are going to be distributed. And in this case, the residual
That's
assets are going to charity, which is amazing. So we want to maximize that impact. So
absolutely.
we go through a lot of paperwork and there's a lot of deadlines and things like that. And you and I have joked about what day is the best day in terms of paperwork to die. Tell the listeners, what day should they aim for from an administrative
Sure.
perspective?
Preference with either the last day of the month or the first of the month. And that is purely because the brokerage firms typically run their statement cycle on month end. For some unknown reason to me, there are many banks out there who insist on cutting their statements on some random day in the middle of the month, which, if it's just a simple bank account, that's easy enough to calculate a date of death value. But in the case of marketable securities, it becomes a little bit more of a challenge. Nothing that's insurmountable. It's just an additional step.
We have to have some humor in this, right? So I'm
We-
going to aim for like December 31st. Would that be like the cleanest for everybody? Yes.
Well, yeah, actually, it would be.
Okay, everybody. Hang on till December.
January 1st isn't bad either.
Isn't bad either. Okay, cool. We'll aim for one of those days. No, just kidding.
Okay.
But we need some humor.
Yeah.
So,
Oh, there's definitely.
so what are the top mistakes that you see in people's? One of them we could talk about scattered accounts. How can a financial advisor help your job with
Yeah.
consolidating things? Should people consolidate things? In your article, you said it takes the same amount of billable hours to close a $1,000 account than it takes to close a $100,000 account. So walk us through that process.
It's true. Again, it all depends on how the account is titled as of the decedent's death. For an individual's account without a beneficiary designation, the personal representative, once they're appointed by the court, and I think that that's a really important distinction for me to make, you can be nominated in the will, but that doesn't mean that you are the personal representative. That just means that you have priority to serve. You are actually not the personal representative until the court is petitioned and enters an order granting probate and issues the letters of administration. One of the things that makes me chuckle is my clients who seem to think that we just have a filing cabinet of letters of administration that we can pull out at our whim and hand off to them. That is not how that works. The letters of administration are issued by the jurisdiction, and those are the credentials that the personal representative needs to take with them to the bank, the DMV, wherever, to take control and administer the decedent's assets. So what a typical PR would do is they would walk into Bank of America or whatever bank, Capital One, PNC, it doesn't matter, present the letters of administration, present their ID. Some of the banks are going to require a death certificate, which doesn't make sense to me because by virtue of the letters of administration being issued, the account holder is dead. So we're learning that we follow the rules of the financial institutions, whether or not they make sense, because they're the ones in control. So the PR walks in, presents their credentials and whatever else the bank is requiring. They walk out with a check payable to the estate of the decedent. They get a new tax ID number because as of the decedent's date of death, you can't use their social anymore. Typically, either somebody on that three-legged stool, usually me, will apply for and obtain a new tax taxpayer ID number for the estate. And then they can open an estate account, deposit that check, and start to pay expenses as needed, and then ultimately make distribution. That is a very, very high level of the process.
So let's talk about something that people can do today. I would probably like building an asset inventory. And I think you mentioned sometimes people are afraid to tell you all the assets they have. That's not helpful in their own interest, right? So then afterwards, right, we have to do a lot of forensics, costs a lot. It won't go to where they want to. So it's better to think through these things and have a plan, right? Or have the conversation.
Yeah, those are valid risks that you brought up. The asset inventory is, of course, critical. Like I said, it changes over time. And we generally tell our estate planning clients, you need to reach out and at least talk to your estate planning attorney if your financial situation changes significantly, if your family structure changes significantly. Those are hallmarks for getting in touch with the attorney. And it may turn out that they're not going to recommend any changes at that time, but you at least need to have that conversation. But things that people can do during lifetime is please, please, please get your house in order. Poor record keeping makes things really, really difficult. And that's another reason for following through on the estate planning checklist and recommendations is it forces you to think about these things and get things in order. Some people, like my mother, she handed me an envelope 2 years before she died and said, everything that you need is in this envelope. And she was right. Now, I happened to be working for the estate planning attorney who put together her plan at the time. So I had everything at my fingertips, but my mother wasn't going to leave anything to chance. And it was super easy and it didn't take much time to administer her estate. Not keeping up with those necessary updates are also critical. You know, sometimes it can't be helped. You're given horrific diagnosis and you literally have 2 weeks. You know what? My suggestion, not advice, my suggestion at that point is enjoy life to your fullest for the time that you have left. And, you know, make sure that, I guess that's my other suggestion is when you're naming fiduciaries, you know, the default is typically a spouse for a spouse or a responsible adult child. That is not always necessarily the best. And again, this is why the estate planning attorney asks about family and wants to know who's alive, who's not alive, who gets along, who doesn't get along. It makes a huge, huge difference.
Right. I mean, that's part of financial planning too, is, you know, I always encourage people to gather all the assets. So, you know, you can see the complete picture and we can plan accordingly. And then I do regular check-ins with them to see if anything has changed, but also like the world changes, laws change. So these things all can affect financial plans, estate plans. So it's always good to keep a regular pulse on things. Here's a scenario you've seen. A will says divide everything equally among my 3 children, but the 401k, which might be the largest asset, still lists the ex-spouse as a beneficiary. So then what happens? This is your favorite one.
Actually, that one's not necessarily the most challenging. In the case of a second marriage, or let me back up, in the case of a divorce, the marital settlement agreement should spell out what happens. Yes, the individual needs to, just like, you know, I've signed my will, I'm done. No, that's not the case. It's the same thing with a marital settlement agreement. You sign the agreement, but there's probably a little bit of homework to do on the back end. Do the homework.
Right. It's all so much homework, but it's all worth it. It's a lot of homework.
Yeah, you know, and just to take a step further, if there is a subsequent marriage, talk to your estate planning attorney about a prenuptial agreement or a postnuptial agreement so that everything is clear, especially when there are children involved, whether they're minors or not as of the marriage. There are a lot of variables here at play, and I cannot underscore the importance of getting professional advice.
So when do you need a team of professionals? At what point? You would say all the time?
Well, yeah. I mean, from what I've seen and from my own life experience, the sooner you can pull these people in, the better off you are.
Right. In the long run.
Yeah. You know, you give financial advice. You don't give tax advice. You'll alert your clients that they need to talk to their tax advisor about issue A, B, C, and D, but you're not going to opine on that. just like we're not. You're going to see something in one of your clients that raises a flag. Hey, you've got $15 million worth of assets all in your individual name. I'm not sure that that's the best titling scenario for you. You really need an estate planning attorney to help you work through these issues.
Right, for sure.
And we've really only touched on financial assets. Let's not forget about houses, cars, LLCs, boats, timeshares, safe deposit boxes. Those all have their own rules, and the layperson is not necessarily going to know. And it's also not necessarily the highest and best use of said layperson's time to run all that down, because then you still have all these silos. Whereas the planning team of the estate planner, the financial planner, and the tax advisor can help you see what the Venn diagram is going to look like and what's in the middle.
Yes. You can actually save yourself a lot of time and resources by doing that earlier than leaving that later.
Absolutely, because your time has value also. I think one of the greatest things is realizing that.
Yes. And you want to do this when things go well, right? Because when things don't go well or somebody dies, you're grieving also. And then you
Yep.
have to deal with all this stuff. It's really a lot.
Exactly.
So,
Right.
is there anything else you would like to tell the listeners that we haven't
Oh,
about
let's
yet?
see. I think we've really covered all of the highlights. I know you're planning on future podcasts with a few of my colleagues who are attorneys, so you can get into some of the legal issues with them a little bit more deeply. But just as far as process, people don't like to pay their attorneys and they like to try to do things themselves. And from my 17 years of experience, I can tell you it's a lot less expensive to turn things over to your attorney paralegal team than trying to do things on your own, mess them up, and then come back and ask us to fix it. The fix is always more expensive than taking our direction and suggestions from the get-go.
Same with financial planning.
Probably with tax planning as well.
Yes, definitely. People could really save so much if they enlisted the three-legged stool that you speak of. I think people just don't know. And you are the paralegal. You see all the nuts and bolts of it. It's so important, that people don't think about these things until they actually have to go through it. And then they realize it's such a huge headache. It really is worth.
It doesn't have to be.
Right. It doesn't have to be. If you plan and get things aligned ahead of time, everything's in place. And then, your adult children or your surviving spouses can be in a much better place to not have to deal with this while they're grieving on top of that. So this has been very valuable. Thank you for sharing all of your insights. You're really in the trenches, so you know all of it. You know the insides and outs of it. So yes, this has been wonderful. Thank you, Bettina.
You're welcome, Marianne. Thanks so much for having me.